Good morning and welcome to the JBDC Virtual Biz Zone. Thank you so much for joining us. My name is Sansia Campbell and I'm the Partnerships and Events Coordinator here at the Jamaica Business Development Corporation. We want to thank you so much for joining us another time for another edition of our virtual Biz Zone. And as is usual, we have a very interesting topic to discuss this morning. We are going to be talking about decoding data protection. And we decided to just put some spotlight on this topic once again because it is so important that MSMEs understand the importance of protecting the information of the persons that they do business with. It's no longer cool or normal for you to use persons' information as you have a like to, basically. You must use it for the for the purpose intended. And so we thought that we would delve into that one more time just to give you some information so that you can go out there and be great as entrepreneurs. So, of course, as you know, whenever we have these sessions, we are going to go for the experts. We're going to find those persons who have the requisite information and we're going to invite them and they're going to say yes and they are going to share with you. And so I have with me this morning Mr. Andre Palmer, and he is the head of practice at Secures Jamaica Limited. So let me tell you a little bit about Andre. He has been working in client engagement roles in Europe, North America, and the Caribbean for over 10 years. He has developed the skill of probing and understanding client needs through careful exploration of strategic objectives and associated execution challenges in order to develop, align, and implement creative solutions to resolve some of the most complex business challenges, resulting in reduced operating costs, greater efficiency, and increased profitability for the enterprise. No doubt data protection will be important in all these regards. So we're going to be looking at adopting the new acts in your business. So I'm going to hand over to Mr. Palmer, but before I do, I must let you know that the session is being recorded. And so if you have to leave, or if you know someone who wanted to be here, but for whatever reason could not be here this morning, we have the session recorded and it will be available on the JBDC YouTube channel. All you will have to do is just go on there and click on subscribe, and you will be notified when the session is available. And you can also binge watch because there are several other biz zones, previous biz zones available. So the sessions are recorded. It's going to be interactive. It's going to be fun. It's going to be interesting. Please feel free to ask your questions, and we'll come back at the end of it and talk about what we learned today. So thank you very much, and I now hand over to Andre Palmer. Thank you.
Thank
Over
you.
to you.
Thank you so much, Sancio. Thanks to the JBDC for having me. Good morning, everybody, and welcome to today's webinar. We're going to be talking about the world's most exciting topic, data protection. I mean, of course, I kid. We know that data protection and data privacy is not the world's sexiest topic to talk about, and a lot of people still see it as this burdensome compliance requirement. So I want to enter into a kind of negotiation with you this morning. Right? I don't want to be talking to initials on a screen, but I'd love to make this session as interactive as possible. So I invite you to ask your questions. I invite you to share your experience. I invite you to share your comments and your thoughts. One of the things that we do know is that the law, as it has been framed, is not perfect. There are a number of things that we've realized they're just not working for Jamaican businesses. So we're not necessarily here to ventilate the technicalities of the law and whether or not it is right or wrong, because the law is the law and it has been passed. So we agitate for change, but while we do that, we still have to comply. So the ethos of the conversation today is really just going to be talking about what you need to be doing as organizations to adopt the law within your business. Sansi, I'm going to ask you to man the chat for me, and just to alert me whether, if there are questions. And if you see me gazing away, I have a couple of screens set up. So, but I'm with you fully.
All
Okay,
right.
so how are we going to spend the next couple of hours? We're going to be talking about data privacy from a global context so that we can understand how the Jamaica Data Protection Act was conceived and some of the driving considerations behind the formation of the act. We're going to talk about what we call the nucleus of the Jamaica Data Protection Act. Those two things being processing standards and the rights of data subjects. Then we want to also talk about your responsibilities as organizations or data controllers, as the act describes you. Talk briefly about the road to compliance. Then what does your business look like if you could contemplate, or if you should contemplate the the role of privacy as more than just a compliance hurdle? What could that do for your business? So we want to talk a little bit about beyond compliance, and then we'll have question and answers. But like I've said, if you do have questions or comments or thoughts that you have throughout the presentation, do feel free to interject at any point with those. Okay, good. All right. So I have a couple of questions that I usually always start with because I want to frame this in the context of just a baseline of where we are, what our current understanding might be, and where some of those gaps are. So the first question I'd like to pose to you is, do you think that you have sufficient understanding of what is required of your organization under the Jamaica Data Protection Act? You don't have to necessarily answer, but think about it. You could drop a yes or no in the chat if you think you do or don't. The second question is, are you aware of all of the personal data that is collected and processed by your organization? Names, email addresses, telephone numbers, TRN, NIS, someone's home address, all of that stuff. Are you aware of all of the personal data that your organization collects and processes? The third question is, do you know of all the places in your organization, whether those are physical repositories or electronic repositories? Are you aware of all of those places within your organization where this information resides and who has access? Whether that is a security logbook, whether it is a book that the receptionist keeps with the names and details of who called and why, all of those things. Are you aware of all of those repositories? And then the final one is it's a little bit more personal because I want to frame this in the context of how this relates to both you and I as data subjects. Have you ever had your personal information compromised or misused? Information that you've provided to an organization, has that ever been used in a way that you did not intend for it to be used? Whether you got an unsolicited telephone call or tons and tons of emails promoting a good or a service, or all of these text messages trying to sell you something. I'm sure that many of you can relate to that because these are things that we encounter on a daily basis. And we're seeing more and more individuals are becoming a little bit frustrated with how organizations are either mistreating or abusing their information, their personal data. And it's not just a Jamaica thing. This is something that is happening around the world. In fact, in 2024, Forbes did a study. They surveyed a number of organizations in about 80 countries around the world. And the question was asked, what are the top 10 things that you are focusing on this year as strategic business priorities? And more than 70% of the respondents indicated that data privacy and data protection was one of the things that they were focusing on as a strategic business imperative. And that is because organizations are recognizing the dangers and the risks inherent with processing personal data on a large scale. When we think of organizations like Facebook and Twitter and Google, a lot of these organizations have been able to build these massive empires on the back of personal data. A lot of them, if you think about Facebook, Facebook does not manufacture anything. Facebook does not, store anything in physical format in that kind of way. What they're trading largely is in this realm or the industry of data. So organizations are recognizing the personal and inherent value that data has, and they're looking at ways of monetizing that or using that in more efficient ways across your business. But in doing so, they're also recognizing that there are inherent risks associated with that kind of processing. And as a result, we see that around the world, organizations are focusing on data privacy and data protection as either a strategic advantage for their business or a strategic risk that they would want to manage or a strategic opportunity that they want to harness. And we'll talk about that in a little bit more detail towards the end of this presentation. Having said that, though, one of the things that we are very conscious of, and we drive home this fact every single time we talk to organizations, and that is really simply that data privacy is about people. Data privacy is intended to protect individuals. And once we kind of get that, we realize that the statement reminds us that behind our day-to-day processing activities are living people who can suffer real and irreversible harm if their data is compromised. And that is what, if you take away nothing at all from this presentation today, this is what I'd love for you to take away. The fact that data privacy fundamentally exists to protect human beings about whom data is being collected. Now, this is not just, like I said before, something that is happening in Jamaica or in our region. And this is not something that is happening just, over the last couple of years. We, Jamaica, we are new to the game. And in a lot of ways, we're playing catch up. So while we've been talking about the Jamaica Data Protection Act since, 2020? Well, we started talking about it a little bit before that, when there was this whole conversation between around NIDS. And there was the decision that there needed to be some mechanism to reassure Jamaican citizens that, their data would be kept safe. So that's kind of when we started hearing about it a lot. But data privacy has been around for much longer than that. In fact, Sweden had a data protection regulation since 1973. And one of the things that has really influenced the development of our laws generally has always been laws from the UK and Europe more broadly. So the Data Protection Act, a Data Protection Act was passed in the UK as far back as 1984. That's half a century ago. And well, almost actually, well, close enough to half a century. My math is off. That's what, 41 years. But that's a long time. I mean, longer than a lot of you have been alive. And then, we see how that has evolved to become what we now know as GDPR. A lot of that, what is now contained in GDPR, actually had its genesis in the 1984 Data Protection Act that was passed in the UK. No, you will hear a lot of reference being made to GDPR because that is the world's most far-reaching piece of legislation around data protection. It affects organizations irrespective of where they operate, as long as they are processing personal data that's related to residents or citizens of the European Union. So if you are a hotel based in Jamaica and you are processing personal data for someone who lives in Germany, for example, the general data protection regulations coming out of Europe also applies to you. So that's the kind of impact GDPR has had. Now, because it's been so comprehensive and because it's been so far-reaching, a lot of other jurisdictions around the world have developed their data protection regulations modeled from GDPR. So when you look at the Jamaica Data Protection Act, it looks very similar to GDPR. It's not as robust, not as detailed, not as cumbersome in some instances, but a lot of the principles are actually mirrored from the General Data Protection Act. So let's now talk a little bit about the Jamaica Data Protection Act and some of the I guess the evolution of it. So the act was passed in the lower house in May of 2020. I think it was tabled back in 2017, if my memory serves me correct. The in June of the very same year, in 2020, the act was passed in the Senate. Now, in December of 2021, Jamaica's first information commissioner was appointed. And this is significant because there was a provision, or there is a provision in the act that says that organizations would have a 2-year transition period from the appointment of the information commissioner until the act obviously became effective or came into effect. So Celia Barclay was appointed in December 2021. That then meant that the act would come into effect in December of 2023. During this 2-year transition period, organizations were expected to do the training and sensitization with their staff around what the act was requiring of the organization. Organizations were expected to develop the policies and procedures to guide the organization in terms of how data was collected and stored and processed and shared and all of that stuff. Organizations were expected to develop a data privacy framework so that you would have a mechanism within which to manage personal data within your organization. In essence, get your hoses in order. So that was a 2-year transition period. We got to close enough to November 30 when data controllers were expected to register with the Office of the Information Commissioner. And, the government realized that the regulator's office wasn't necessarily quite ready, but also data controllers were saying, we need a little bit more time. We are not entirely ready to embrace this. We need a little bit more time to develop policies, to do the training, to develop a framework, to do all the things that were required to get us compliant. And a 6-month grace period was granted. So organizations were given an additional 6 months on top of the 2 years, the 2 years of transition period. An additional 6 months was given, which then meant that registration would have commenced or should have commenced should have concluded by May of 2024. Right, so May 2021, the registration, the grace period ended, and data controllers were expected to register with the Office of the Information Commissioner. And on December 1, 2024, year 2 of the registration process started. So as you can see, it's been around for a little while. It's been about 5 years. And I know that a lot of organizations, in talking with organizations up and down the country, we know that a lot of organizations have not necessarily started anything. You haven't necessarily done the training and the sensitization. Some of you have not done any kind of registration with the Office of the Information Commissioner. You haven't developed a mechanism to guide how you manage personal data within your organization. And you are at the point now where you're saying, I don't know what to do. It seems like a lot, and it seems like a huge compliance burden, and the panic is setting in. A part of the conversation that we want to have today is don't worry. Yes, we're a little bit behind the 8 ball, but it's going to be okay. There are a lot of organizations out there, I can tell you, that are in worse shape. And the regulator also understands that it will take some time. With any new law, there is going to be a bit of period, a period that organizations are navigating the complexities of compliance. And what we're saying, so if you don't realize, that's me there on the screen. But the only thing is, I have in this particular drawing, I have hair. And right now I don't, but you can see the beard is the same. The grays are setting in, but let's imagine that that's me. And that's me saying to you, it's going to be okay. We'll talk today about how you can actually do some things very quickly to drive compliance within your organization and to move from a point of zero action to at least being seen to do something. In a lot of cases, when the regulator, if something should go wrong within your organization and the regulator launches an investigation, they're first going to look at what you have been doing in order to comply with the act. And I can tell you, chances are the regulator will look a little bit more favorably on you if you at least started the training, or you at least developed a privacy policy, or you at least registered with the Office of the Information Commissioner. They'll go, okay, at least we see that company A has taken some action towards compliance. If, on the other hand, the regulator comes and does some kind of investigation after a breach or leak, and they realize that you haven't done anything at all, then it is going to be said that, boy, you didn't take this thing seriously, and your inaction led to the breach or leak, and by extension, any kind of harm that the data subject has been exposed to. So what's the purpose of the Jamaica Data Protection Act? It is really there to protect the privacy and integrity of data held on individuals by businesses and organizations. Like I said, it is really meant to protect people. The law is not concerned about financial data. It's not concerned about corporate data. It is really only concerned, the Jamaica Data Protection Act, that is, with personal data or personal information. And a definition provided in law, in the Act, of personal data is any data that is used either by itself or in combination with other pieces of data to identify a human being or anyone who has been dead for up to 30 years. So the Jamaica Data Protection Act is a little bit unique in that it extends to the dead. Anyone who's been dead for 30 years also, their data needs to be protected in the very same way that living people's data are protected. So data privacy, put another way, generally means the ability, or giving human beings or persons the ability to determine for themselves when and how, to what extent personal information about them is collected, used, stored, and shared with others. So privacy is something that we maintain for the good of ourselves as organizations and the good of others. And I said before, we're living in a data-driven economy, and there's this perception that more data is good. And the more data we have, then the better off our organization will be. And the more we're going to be able to make insightful decisions or data-driven decisions. But we have to also understand that the more data we have, the more burden we have created for ourselves in terms of keeping that personal data that we've collected safe. And I'll talk a little bit about that when we get to the processing standards. Here we are. The law, the nucleus of the law of the Act, actually, let me just pause a little bit just to see if there are any questions, comments, thoughts so far. Corinne says, yes, I have had my personal information shared in mass email instead of BCC. There we go. Then the recipient does the reply all, and then everybody inbox is flooded with messages not meant for you, only the sender. So I think that's a very, very classic example, and something that I think we can all say that we've been exposed to. Or I don't know if you've ever been in you've part of these organizations where someone is sending personal detail, but then they CC everybody, and then somebody's, someone's payslip is exposed, or their medical records might be exposed, and so on. Late adopters, the OJ office collects your information in an open office, and everyone can hear and know your details. And that is something that came up, I think, might have been just yesterday. Someone was talking about an experience at the Tax Administration Office of Jamaica, where they were at the window, the cashier's window, and they were being asked to shout out their TRN number or something else, and if you've been to a tax office, you know what the setup is like. So to stand at the window and to be shouting your personal details in full earshot of everybody who's in the waiting hall, that again is, that should not happen, because that actually is creating a situation where your personal details can be compromised. Okay, so there is a question. Last minute delays and extensions. Why did organizations wait to start the process? Good question. No, again, with a lot I guess whenever there's a new piece of legislation that requires that we do things differently, there is always some uncertainty. The question of what do I do? Where do I begin? How much is this going to cost me? How disruptive is this going to be to my business? And what is the change management procedure that I should implement to manage this kind of change? Because this is a new change. You're introducing a new way of operating, which is a form of change that needs to be managed properly. So there are all those questions that a lot of organizations couldn't necessarily grapple with. Some organizations just did not have the resources. Some organizations didn't quite understand what the law meant and what the law was asking of them. Some organizations weren't necessarily sure whether or not the law applied to them, because there are some exemptions, not from the entire act itself, but from some provisions within the act. So some organizations weren't entirely sure. Then, of course, there's a cost component. Organizations were thinking, well, this is going to be really costly. I don't have that kind of money to spend on what is essentially a compliance activity. So I'm going to delay this for as long as possible. And then there is the decision inertia, where organizations just, because they get overwhelmed, they just freeze and do nothing. They intend to do something and they want to do something, but then because of the weight of that decision, they just freeze and they do nothing. And and I think on the surface too, some organizations are just negligent because they don't quite understand the penalties, let's say, or the consequence of some of the consequences of non-compliance. So we'll talk about that in a little bit. So it's for a number of reasons that some organizations are yet to take action. Okay, all right, let's talk then a little bit about some of the processing standards, and then I'll jump in and out of the chat just to see the questions. So the processing standards, along with the rights of the data subjects, are what we like to call the nucleus of the Act, what the Act is really about. So there are 8 processing standards, and these really dictate how organizations should be collecting and processing and storing and sharing personal data. So let's start with the first one. This says that organizations or data controllers, whenever I talk about data controllers, by the way, I am referring to organizations who decide what personal data is collected, why it is being collected, how it should be stored, how long it should be stored, who should have access, what the data should be used for, who it should be shared with, and ultimately how and if it is deleted. So a data controller is the organization that is responsible for making decisions about how data is processed. They make the decision. You'll also hear me talk about a data processor. A data processor is a little bit different from a data controller. A data processor, based on the definition of the Act, says it means any third party, so that could be an individual or a company, any third party that has been contracted by the data controller, by the primary decision-making company, to carry out a processing activity on its behalf. So this is any person or entity other than an employee of the data controller. So for example, if you are a data controller and you have engaged the services of a third party to do your payroll processing, the payroll processing company is a data processor because they're carrying out a processing activity at the direction or on the instructions of the data controller. Now, the thing to remember here is that the processor, the data processor, can only do the things that the data controller has mandated it to do. The minute the data processor decides to do other things and they're acting outside of the directions or the instructions of the controller, the data processor has made itself a controller, because now it has started to make decisions on its own about how the data is processed. So for example, you've contracted a third-party company to do payroll. You provide them with your employees' details, their names, their email addresses, their TRN, their NIS, their salary details, and all of that stuff. And all they're meant to be doing is processing payroll and sending them a pay slip by email. That's the instruction that's been given. What this data processor now, this payroll company, what they start doing now is they start send their email marketing. So now they have the email addresses of your employees. They start to send them email marketing about services that they provide around tax filing, for example, or providing software, or they have a pension management component. So they're sending them marketing information about that, or they help them with investments. They look at your staff list and they say, oh, these are the 5 high net worth individuals. Let's introduce them to our investment portfolio. So now they've started to make decisions about the information that you have provided to them. So they've moved themselves from a data processor to a data controller. And we will get to a section in this presentation where I will talk about why that matters, because I know that a lot of you on this call are classified as data processors. So I'll talk a little bit about why that is important. So I've talked about data controllers. I've talked about data processors. The next term you'll hear me talk a lot about is data subject. And a data subject really just means individual. It means any person, individual, me and you, or anybody who has been dead for up to 30 years, who is the subject of personal data. So when you hear me use those terms, I just kind of wanted to give an indication of what they mean. Okay, so now we go back to the 8 standards. Standard 1 says that organizations or data controllers must process information in a way that is lawful, fair, and transparent. Simply put, this means that you have to tell the data subject, the individuals, what you're doing with them data, why you're doing that with their data, how you're going to be storing the data, how long you're going to be keeping it, whether or not you're going to be sharing it with any third party, and also inform them of their rights. So you can either do this by having a data privacy policy, a data privacy statement, or a privacy notice. A data privacy policy is an internal facing document that informs the organization around your philosophy when it comes to data privacy and protection. It is telling them, it's almost like a blueprint or a guideline that helps the organization to understand its responsibilities as far as processing personal data is concerned. So that's the policy, which is an internal facing document. The privacy notice or privacy statement is an external facing document. So when you go on to websites, you will see a privacy notice or a privacy statement. And it is there to inform the data subjects, individuals, about what information is being collected, why the information is being collected, how the information will be stored, how it will be used, whether or not it will be shared with any third parties, and the measures you've put in place to keep the data safe. It will also inform the data subjects of their rights as it relates to their personal data. And generally, too, it will also include how they can contact the organization, including details of the data protection officer if you have appointed one. So that's the first standard, just to really ensure that you are processing data in a way that is lawful and fair. And by that, we just mean having a privacy policy, a privacy statement, or a privacy notice that informs either the organization around their responsibilities or the data subjects around their rights. The second standard, standard 2, is purpose limitation. And Sansia talked about this at the beginning when she was introducing today's conversation. And purpose limitation really just says that personal data, purpose limitation that is, says that personal data should be obtained for a specific, limited purpose and shall only be used for that purpose. So let's take a very practical example. If you go to a bank to open a bank account and they say to you, we want to verify that you are who you say you are, and we want to ascertain source of funds. So in order to do the ID verification, they want a form of ID, whether that is a driver's license or a passport. And for source of funds, they want your last 3 months payslip. Remember, this is ID verification and source of funds. And they verify that Sansia is who she says she is, and all is well and fine. You open your account. What the bank can't then do is pass your pay slips to the wealth management department to say, oh, we see that this particular person would be a great candidate for the wealth portfolio. And then someone from an investment manager starts to call you to introduce you to products and services that the bank is offering as part of their wealth division. Because remember, that was not the purpose for which you provided your pay slips. Your pay slip was just for the purpose of verifying source of funds. And if that is the purpose for which the organization has collected it, then they can't use it for a secondary purpose for which you have not consented. So the purpose limitation is a really tricky one because organizations have a way of collecting information for one purpose and then using it for something else. No, under the Jamaica Data Protection Act, we as organizations have a responsibility to only use the personal data for the purposes, the very limited and specific purpose for which you've collected it. Inherent in this particular standard too is the responsibility of the data controller of the organization to inform the data subject around why you are collecting it. So the term specified or specific purpose simply means that you have to indicate the purpose. So the bank has to say to you, I am collecting your ID, that being your driver's license, your passport, in order to verify your identity. Or I'm collecting your payslips in order to verify source of funds. Or I'm collecting your phone bill or your JPS bill in order to verify your proof of address. So you have to state why you are collecting the information as part of the limited specific purpose limitation piece. Then there is a standard around data minimization. Remember, I said earlier that more isn't always a good thing. And this is kind of what the law is seeking to enforce. Data minimization says that personal data shall be adequate, relevant, and not excessive. So think about the reason for which you are collecting the personal data and think about whether or not you can do that processing without all of the data that you want to collect. So if I come to your particular, say you are a supermarket or a wholesale, and I come to you to buy, to do my weekly shop. But at checkout, you're asking me the average, how many people are live in my home. You're asking me about my mother's maiden name. You're asking me about the average income of my household. You're asking me whether or not there are any dietary restrictions. You're asking me about the age of my children and their dates of birth, for example. I'm sure you will find that odd because you're thinking, well, what does that information have to do with me just wanting to buy some milk and some eggs and some bread and some cereal? So you think about, whether or not the amount of information a company is collecting is proportionate to the purpose for which they're collecting it. So the data minimization says you should only collect information that you need for the specific purpose that you have stated. I mean, I'm sure you've come across examples, and you can drop some examples in the chat where you've been asked for your personal details, and you're thinking, wait a minute, what does this have to do with anything? When you go to buy a pay-as-you-go SIM card from one of the telephone providers, and they're asking you for your mother's maiden name, and they're asking you for your address, and they're asking you for your TRN number, and they're asking you for all of these other details. I know they say it's that, to help to prevent lottery scamming and all of that stuff. But in a lot of cases, people just feel that some of those data collection measures are a little bit excessive. And the fourth standard that the Act talks about is the standard around accuracy. It says that organizations have a responsibility to ensure that the personal data that they're collecting is kept accurate and up to date. So if someone changes an address, is there a process internally within your organization to notify you that someone has moved homes and their home address that you have on file needs to be updated? If someone has gotten married or divorced, for example, is there a system in place to allow them to notify the organization of that change in that personal details? So the information that you've collected, you have to have some mechanism in place to ensure that it's kept accurate and up to date. That the burden that responsibility is the organizations to bear, the data controller. That's your responsibility.
Andre.
Sure. Yes.
I want to interject because there are so many messages in the chat, so many questions.
Sure. Let's take some of them.
I'm gonna start from the bottom.
Mm-hmm.
Somebody says Western Union. And I'm suspecting when they go to Western Union, someone will say to them, what am I going to do with the money?
Yes. So again, there are some other laws. So there are POCA, regulations, Proceeds of Crimes, the Crimes Act, Proceeds of Crimes Act, as well as international money laundering standards and counter financing and anti-terrorism measures that require some financial institutions, especially those that do international transfer of money, to ask certain questions to verify that the money is not from an illegitimate source and it is not going to finance criminal activities or acts of terrorism. So sometimes, that question may be asked. In some cases, though, they are a little bit excessive. So again, that is also part of what legislations like the Jamaica Data Protection Act is also seeking to curtail the excessive collection of information as well. So yes, so the point to note here is that the JDPA does not stand in isolation from all of the other laws that are existing, whether they are POCA legislations or AML legislations. So, they're meant to operate in harmony. So as long as they can justify why the information is needed and necessary, then that's fine. So there's a legal basis, what the law calls a legal basis for processing the data.
All right, more questions, more questions. Somebody said, why do I need to sign a visitor's log?
So again, that is for a number of reasons. It could be for health and safety measures. If you visit an organization and they want to know what time you've come into the building, who you are in the building, as a health and safety feature. So if there's a fire or an earthquake and everybody has to evacuate, can they account for you? If they have no record of you entering the building, then it's hard to account for you in the event of an emergency. But generally, though, like I said, remember we talk about the purpose limitation. Contained within the purpose limitation is the obligation of the organization, of the data controller, to inform you why they're collecting that information. So when you get to the security booth or you get to the reception's desk and they're asking you for your name, or to send a visitor's log, you may want to ask them why. You can challenge them. You can say, why is this information needed or necessary? Again, if they may tell you it is in the event that we need to conduct an investigation around a criminal act at a later point. So say, for example, you come into someone's building and you commit an act of vandalism or theft or assault, whatever it is, that information may later be relied upon as part of a criminal investigation. So organizations will have a number of different reasons why they're collecting data in the form of you signing up a visitor's log, but they have a responsibility to inform you why that information is needed and necessary.
All right, one last question before you move on. So this person is saying, why is a utility bill required for proof of address when they're not going to mail correspondence? Email is the communication method.
Yeah, that's a very good question. That's an excellent question because gone are the days when we're doing physical mails to someone's address. But I suspect it is also needed and necessary in the event that they may need to find you. In some cases, when you're entering into a contract. So one of the lawful basis for collecting personal data is performance of a contract. When you've entered into a contract with an organization, and there is the possibility of a breach of contract occurring. So, for example, you have gone into a contract with, say, courts, for example, and they have provided you with furniture on hire purchase. The contract that you've signed is that over the next 12 months you are going to pay courts $100 towards this fridge until it's paid off. They want to know where you live. So in the event that you renege on your part of the contract and they need to send a registered mail to your house, or they need to send a summons, or they need to send a bailiff or whatever, they know where to find you. Or in the event that there is a court proceeding, a lot of these things are actually delivered to physical addresses. So in a lot of cases, once you've entered into a contractual arrangement with a company, a provider of goods and services, and there is a possibility for a breach of contract to occur, and they may need to know where to find you, then a proof of address becomes needed and necessary in those particular cases. But I do agree, not in all instances will a proof of address be needed. And again, so one of the things, remember that the Jamaica Data Protection Act exists to give you, data controllers, control over how your personal data is being used. So don't feel any kind of way to ask an organization, with all due respect, can you help me to understand why this information is needed and necessary? And if they have trouble telling you why they're collecting it or processing it, chances are they should not be collecting it. The law also says that the organization cannot refuse you a good or a service simply because you refuse to provide information that is not needed or necessary. And we'll talk about the role of the regulator as well as court proceedings in that particular case. Like I said, this is a very new way of operating. So a lot of organizations are really wrapping their heads around what this means for them as far as the information that they're asking people for and being able to justify why they're collecting it. So a lot of it comes down to the justification piece. Can you justify why you are collecting this information? As long as you can justify it and there's a legal basis, we say, okay, fine. But if an organization is having difficulty justifying why you are collecting the information that you're asking for, chances are you should not be collecting it. Okay? All right, good. So there are a lot of questions. So I will, Sansi, I'll allow you to keep an eye on the questions and then just interject when you want us to, entertain another few questions. Okay, so we talk about lawfulness, fairness, and transparency as a processing standard, purpose limitation, data minimization, and accuracy as the first four. Now let's look at the other four processing standards. There is, in standard 5, a requirement for organization to keep personal data for only as long as necessary. So this is called storage limitation. I know that organizations have this tendency of keeping data forever, especially now that we have, lots and lots of cloud space that is just really cheap. Back in the day when we were keeping physical records or when we were buying electronic storage, and it was actually quite costly, organizations were a little bit more inclined to get rid of information that they deemed unnecessary because it was a cost to the organization. No, cloud storage is so cheap that you can keep hundreds of thousands of emails forever. You can keep hundreds and thousands of personal records forever. You can really just keep data forever. But the law now requires you to think about a retention period. So ask yourself, why, if someone has worked for me 15 years ago, why do I still have their entire personnel file in a filing cabinet somewhere or stored electronically in the cloud? Why do I need that? Chances are you may still need some elements of their personal file to be kept. So you have to do the exercise of deciding what bits of information you are going to keep and why and for how long. You can't just keep everything indefinitely. So chances are you probably, once an employee leaves, 1 year and a day after they've left you, chances are you no longer need their banking details because you're not going to be paying that person thereafter. So why do you still have their banking details, for example? So this requires organization to think carefully about what you're keeping, for how long, and why. A lot of organizations ask us, well, what is the required retention limit? There is none, unfortunately. We wish we had a magic bullet or a silver bullet that says, yes, it's 7 years across the board or 5 years across the board. As an organization, you will have to do the work department by department to decide what bits of information you keep and why. Some bits of information you want to keep for 7 years because of statutory limitations. Somebody could bring a court proceeding against you and you may need to rely on the information. So in that particular case, of course, you can keep that because you've decided that that is a legal basis, on which you want to rely. Or you may say there is another piece of legislation that requires me to keep financial data in this way for 7 years. Or because of an audit, you may need to keep this for 3 years and so on. So you have to go department by department and decide the bits of information that you have to keep and for how long. But the law requires you to be able to demonstrate that. It's a lot of it comes down to you being able to demonstrate why you are doing what you're doing as far as the retention of personal data is concerned. And then there's a standard around allowing data subjects to exercise their rights. I'll talk about that in a little bit more detail. So I won't necessarily focus too much here. Standard 7 talks about appropriate safeguards. It means that organizations are now required to put the appropriate technical and organizational measures in place to keep the data safe. You're protecting the data against unlawful processing, accidental loss, damage, or destruction. Now, this could be something as simple as you locking your filing cabinets when you leave at nights, or you having your CRM system, as a password protected application, and only people with the required login details can access your CRM. It's not just a single sign-on that everybody within the organization can access, or only people who need to see your sales log, whether it is, someone in accounts receivable or payables, they're the ones that are going in. So it's not a case that, all aspects of your business are open to everybody, but you're also putting in place measures to limit what people can see and do within certain applications or files as far as protecting personal data is concerned, or accessing personal data is concerned. And then the final one is around international transfer. And this just says that organizations now have a duty to do some due diligence to ensure that third-party countries that you're sending personal data to have some kind of data protection law in place to keep the data safe in the same way that you are expected to keep the personal data safe. If a law does not exist, then what is the organization doing to keep the data safe? So we always want to start with a national, some kind of legislative framework. But if that is non-existent, then you want to do some work to satisfy yourself that the organization itself has some safeguards in place to keep the data safe. Because ultimately, remember that as the data controller, you are the one that is responsible. Before I jump into the rights of the data, the rights of the data subjects, we can perhaps entertain another few questions. Sansia, and in particular you want to?
All right. There are so many comments, Andre. I don't even know where to start. All right, so I read
Okay.
something here from Junior. He says, the banks always ask for persons to submit proof of address in the form of a utility bill. However, I've been told that there's often a secondary reason why this is asked for, that this is mostly unstated to customers. They look at utilities to see if you have a balance brought forward and use this as a measure of your likelihood to pay without being chased. Is this ethical or legal? And how should this be treated by both the banks and the customers?
The answer is no. It's not legal. And it's not ethical because it's misleading. If the bank has said to you that they're collecting or they're using your utility bill for the purposes of verifying your address, then they can't then use it for a secondary process, which is to determine your likelihood of paying without being chased, because that is not the stated purpose that they have that they claim. So remember, when we talk about purpose limitation, the law requires that it can only be used for one purpose. Now, if they're using it in that way, and that is something that we do know, then that is, there are legal remedies available to us through the regulator as well as through the courts. The question is really going to be one of whether or not that is something that we can prove. Can we prove that that is in fact what the bank is using that utility bill for, right? So again, it obviously comes down to ability to prove.
All right. There's another one. When it comes to sole proprietors selling a product or service to customers, where they require data such as name, address, banking info, etc., expand a little on how the Data Protection Act will be applicable to that.
Hold on, sorry. Say the first bit of the question again.
So when it comes to sole proprietors selling a product or service to customers where they require data such as name, address, banking info, etc., expand a little how the Data Protection Act will be applicable to that.
Okay, yeah, good question. Because there are a lot of small organizations that go, well, because I'm small, the act doesn't really apply to me. But once you are processing personal data, then the act applies to you. And the definition of processing within the Jamaican Data Protection Act is a very broad definition. It means collecting, storing, analyzing, viewing, sharing, moving, deleting, changing personal data. So the minute you've collected someone's name, you've processed personal data. The minute you have written it down and put it in a filing cabinet, you've processed personal data. The minute you've typed it into a POS system or CRM system, you've processed it. So we say to organizations, if you don't need the data, then don't collect it, because once you've collected it, you've given yourself a responsibility to protect it in the way that the Jamaica Data Protection Act requires you to. Now, as a sole proprietor, well, contained within the law is this idea of what we call there's the legal basis. What is the legal basis for which you are collecting the data? One, and two, as a business, is there a legitimate interest? So a legitimate interest just says that in order for me to carry out my business, then I need this information, and without this information, I can't offer you the service. So if you come to me, for example, if I'm a sole proprietor and you've come to me um to buy something, so let's just say a pay-as-you-go SIM card, and I need your name and I need your banking details because of where you're going to be paying. Without that, I can't offer you the service. Simply put, that's the way the business is structured. If I don't have that information, I cannot offer you the service. So that is what the law calls legitimate interest. It is legitimate. It is in the legitimate interest of the business to have this information. Now, you still have a responsibility to inform the data subject. Some of it might be apparent and some of it might be very, very obvious, but you still have a responsibility to inform or to notify the data subject why you're collecting or why that information is needed or why you're collecting it and how to be protected, and still be able to put that in a privacy notice, so that at least the data subject has some comfort around the fact that you are going to treat this information with care. So the law still applies to you, even if you're a sole proprietor, as long as you are collecting personal information, and you still have a responsibility to notify the data subject what you're collecting and why. And you also still have a responsibility under Standard 7 to put in place the appropriate organizational and technical measures that are required to keep the data safe.
All right, last question for now. We've spoken about the limitations, but what are the kinds of redress or actions that can be taken in the event of a breach or refusal of service due to someone not being willing to disclose personal information?
Yeah, excellent question. So the first port of call is to the regulator, to the Office of the Information Commissioner. There's a lot of resources on the OIC's website. So you can always contact the regulator to inform them that a particular data controller is refusing to provide you with a good or service simply because you did not provide information that you did not think was necessary or appropriate, or the data controller could not justify why that information was needed or necessary. Then you can also go through do a civil action through the court, because again, the refusal of or the denial of service was done in an unlawful way. So the Data Protection Act also makes it possible for you to use this as a legal instrument in a court of law to seek redress as well. There was a particular case recently. Granted, while the data subject it ruled unfavorably against the data subject, I think it still demonstrated the agency that is now given to individuals, and it was the Corner Elephant Group. A particular person was dismissed, and she was suing the organization for unfair or unlawful dismissal, and she was also asking the tribunal to make a determination around loss of income, because she was dismissed in 2020, and I think the claim, and she was asking for loss of income between 2020 and 2024. Now, the company that dismissed her felt like as though she was working during that period, and as such should not be entitled to loss of income. So they asked her to provide, details around her employment since that time, and she did not. And what the employer did was to contract a private investigator to find out whether or not this person was in fact working. And they found out that she was working for another company, and they asked that company to provide details of her employment since 2020 and 2024. And the individual took the company to court because they felt as though they accessed her personal details or personal data without her knowledge or consent. Because there was a legitimate interest for company A to find out that information. Of course, I mean, it just did not stand up. But I thought it was a really good example of someone exercising their right under the Jamaica Data Protection Act. So there is agency that is now given to individuals to exercise your right, either through the Office of the Information Commissioner, which is the regulator, or in a civil proceedings in a court of law. So yeah, man, there is agency. Okay, all right. So we'll move on, and then we'll come back to some other questions. So let's talk then about the rights of the data subject, since we are on that topic. So there are 6 fundamental rights. There is the right of access, consent or withdrawal, the right to not be subjected to automated decision making, the right to prevent processing, right to consent to processing for direct marketing, and the right to rectification of inaccuracies. So depending on how you look at it, there are 6 rights. So let's take each of them, just quickly go through what they mean. So the right of access means that as a data subject, you have the right to go to any organization that is processing your personal information and ask for a copy of that information. I want to see what you have collected about me. I want to see what it is being used for. I want to know who you've shared it with. And I want to know what you've done to keep my data safe. And I want to know how long you're going to keep it for and how it will be deleted. So data subjects can come to your organizations and exercise that very same right, in the same way that you can, as a data subject, go to any organization that is processing your information. Data subjects that you are processing information for can come to you and exercise their right of access. And under the Jamaica Data Protection Act, you have 30 days within which to make that information available to the individual. So think about what you are collecting, where you are collecting it. Remember, I asked you at the beginning whether you know all of the information that your organization is collecting. Remember, I asked whether you know where that information resides and why you're collecting it and who has access to that information. Those questions are important because it enables you to fulfill this particular right of access. Because if someone comes to you and they're requesting a copy of all of the personal details that you have on them, but you don't even know where the information is, then we have a problem. If you don't know what all the information that you have on this individual, then we have a problem. If we don't know why we are collecting it, then we have a problem. So the right of access one is important. And I suspect what we're going to see and what we have been seeing in Europe are disgruntled employees invoking this particular right because they know they can tie up the organization in unnecessary work to trace down all the information that they have about the particular employee and provide that within 30 days. So the right of access is actually an interesting one. So think about whether or not your organization would be in a position to fulfill this in the event that someone comes knocking on your door. That's the first one. The second one, and these are not necessarily in any particular order, by the way, the second one is the right to consent or withdrawal. So you must get the consent of someone if you want to use their information in a particular way. So if you want to use the information for any other purpose other than the purpose for which you had collected it to begin with, then you have to get their consent. So you may go to a bank and the bank says, okay, we want to see your pay slips and we want to see your ID for ID verification and for source of funds. But that's the purpose. Oh, and by the way, we may share your information with other departments within the bank or other operating companies under the group. Do we have your permission or consent to do that? And you very well might give them the permission to share information with other departments to do other things. but they have to get that consent, that recorded consent, and they have to be clear about what that consent is around. And in the same way that you've given that consent, there should be a process where you can withdraw that consent, because remember, consent is unequivocally given, but it has to also be easy to withdraw, because you can change your mind. What if you agreed? Yes, you can share my details with other departments, but every single week you're getting upwards of 50 emails from sales and marketing, from wealth, from pensions, from investments, it just becomes annoying, and you want to withdraw your consent. So you realize that in a lot of cases, there is the option to unsubscribe when you are, when you're getting additional, when you're getting, emails. And I'll talk about that too around the direct marketing piece. Peter Gay, I see you have a hand up. Peter Gay, you want to unmute and okay, there you go.
Hello. Good.
Hi, morning.
Good morning. So my question is twofold as it relates to my entity and also research. So for my entity, for example, we sometimes, when persons sign up for our services, so we do services in education and career and personal development. So for example, if I go and I do a presentation, you want to take pictures of your engagement with persons and so on. So in our policy, we outline that we take photographs for the purpose of advertising and so on. Sometimes we also work with children. So that is also in our policy as well. So sometimes we ask persons or parents individually if it's okay to use their child for the purpose of advertising this, for example, a reading session. You want to be showing a picture of you sitting down with a child reading for promotional purposes. Does the Data Protection Act come into this? Is it okay where I am at right now currently, just outlining in my policy? Is that enough, or is there something else that should be done? That's one, and I have another question afterwards.
Okay, right. So remember we said that the policies is more the internal facing document. It's a guideline for how the organization should be processing personal data. And it is really there to inform your colleagues, your other staff members around what to collect, how to collect it, where to store it, how long to keep it for, and so on. So consider it the internal guideline. So some of what you've said, it's great. I think you're absolutely doing the right thing by notifying individuals about what you're doing and why you're doing it, where we might be taking your pictures or we may be using it for promotional materials. Great. But I would just say that needs to be in what is called a privacy notice. So the privacy notice, and then you can inform people where they can find the privacy notice, and to also indicate if they would prefer not to be included in any of the thing in your photo capturing activities. So where can people generally find that information that you've said? So is it on your website? Do you normally
Yes, it is. It's on our website. It's on our e-portfolio site that we usually just send persons the link.
Perfect.
And when they're signing up, it's also on the form, so they are able to see that this is what the information is being used for.
Great. So Peter Gay, that's a really good example and a really good practice, because sometimes organizations may have a privacy notice, but it is not publicly available or publicly visible. So the whole point of notifying individuals about what you're doing and why is so that they will have access to the information and they can be informed. So yes, as long as it is publicly visible or publicly available and people know where to find it, and it contains information about what you're doing with their data and why, then yeah, that is really what the law requires of you. So you're absolutely doing the right thing there.
Okay, thank you. And as it relates to research, as we do research as well, and we also supervise research, and there were some concerns as it relates to, for example, a class profile. So you want to understand the background of the population, where they're coming from, and so on and so forth. So I was saying that you can write a general statement. For example, some of them, for example, you might say, many of the students live at, for example, Tivoli or Beverly Hills, and so on and so forth. Persons were like expressing an issue with that because they're saying the data privacy. They're saying that we should not be writing about this type of data and so on and so forth. But I personally don't see why not, because it's not to say I'm saying John Paul lives at Beverly Hills. I'm saying children are from this particular location. And also, of course, we do informed consent. So I want to consider that as part of the thing that we are currently doing. When you have an informed consent to inform process of what the data is, why you're collecting this data, and they can choose, it is voluntary. They can choose whether they want to participate and so on and so forth. But I just want to understand how far does the Data Protection Act really govern it comes on to research? Because can we, for example, write where persons are coming from in terms of where they participated in the research on a general scale? Can we, I understand too many times we use pseudonyms, so we don't use the actual name of the school or we don't use the actual name of individuals. But I want to understand, for persons who are raising concerns, when we do reports, we take pictures, we don't necessarily ask persons, we just, and this is not for me personally, but for schools in general, when we do reports, we take pictures, so we don't necessarily ask anybody's permission. We just put them in the report at the end of the year and so on and so forth. There's not typically an issue, but I just want to understand, where does it stand right now with this upcoming data protection?
Not upcoming, it's already here.
Right.
But yeah, but good question. Right. So Peter Gay, the act is really just concerned with personal data. And when we say personal data, it's defined in the act, and it is any information either by itself or in combination with other pieces of information can be used to identify a human being, a person or anyone who's been dead for up to 30 years. So if the information that you're publishing in your research cannot by itself or in combination with other bits of information be used to identify any single person, then you're completely fine. It sounds to me as though the research is publishing aggregated data. So it is not the specifics, John Brown or a boy in 7th grade that lives in the Papine area who is 5 feet 2 inches tall, of fair complexion and whatever. You're not going as so granular where someone would be able to identify an individual by reading. That's how it sounds to me. So as long as you have anonymized the data and you've made it so difficult for anyone to identify a person just from reading the data, then you're completely fine. That's one of the, I guess, the safeguards that is required for you to put in place, where you anonymized the data. And sometimes, if it is not anonymized enough, people can still, by the process of deduction, be able to guess who you're talking about. But if you're just using aggregated data, if you're saying 27% of all of the respondents are from, the Tivoli area or from, lower socioeconomic backgrounds, however you want to coin it, then that's completely fine, because there is no way that you're going to be able to identify an individual from that kind of aggregated data. So under the Jamaica Data Protection Act, that's completely fine. Yeah. Okay. All right. Thank you, Peter Gay. There was another hand. I think the hand has gone. All right. So, and then there is. Okay. All right. So let me quickly. I'll go through the rest of the rights of the data subjects, and then I'll jump back into the chat, and we can entertain a few more questions. Okay. You're welcome, Peter Gay. Right. So I talked about consent or withdrawal. Now I'll talk about automated decision making last. So let's talk about the right to prevent processing. This just means that a data subject can change their mind. At any point, they can say to you, I do not want you to process my data. You may have come into my data may have been provided to you by a third party. I may have provided my data to you for whatever purpose, but I do not want you to do anything at all with my data. And if they write to you, then this means that you have to stop processing the data. And remember, I said that the word processing has a very broad definition. It means retrieving, it means analyzing, it means sharing, it means any action at all that you perform on data, that's processing. So an individual has the right to say to you, I want you to prevent processing. Now, of course, that has to be taken in context. If you have a legitimate interest in processing, so for example, if I am in a contractual obligation with courts, I have gone to courts and I've taken out a refrigerator on hire purchase, and I have not completed repaying courts, I cannot write to courts and say, I want you to stop processing my personal data. Courts has a legitimate interest to continue processing my personal data because I have entered into a contractual arrangement that is still in effect. So this particular right has to be taken in context. It cannot be exercised in every single instance or for every single eventuality, because there are going to be some instances in which you have to say to the data subject, thank you for your request, but unfortunately, we are not able to comply because of whatever. So you still have you have to respond to the data subject, whether to say we will stop processing your data, or unfortunately, we cannot comply with your request because of this. So you still have to communicate with your data subject. Then there is the right to consent to processing for direct marketing. So remember, you can only ask for someone's, well, not remember, you can only ask for someone's permission to do direct marketing to them once in their lifetime. So if you ask for my permission, would you like to receive marketing materials about new goods and services on a weekly basis, and I say no one time, you can't keep asking me that same question every single week or every single month. You can only ask me that question once. And if I give you my consent to send me direct marketing materials, whether it is by text messaging, emails, by you sending me physical flyers in whatever form, you have to also give me an opportunity to withdraw that consent. Again, when you see emails come out, marketing emails, you will generally see at the bottom an option to unsubscribe or to withdraw your consent. So you have to ask for consent from an individual before you start sending them marketing information. Gone are the days where somebody could just buy a list from an external marketing company and just be sending them. I don't know if any of you have ever gotten these messages from either Flow or Digicel, where you get people advertising parties, or Red Stripe is sending you stuff about the new, flavor beer that they're launching, or you have a bank sending information about, a new product or a service. And you go, but wait, I don't remember giving Red Stripe my details. I don't remember giving this party promoter my telephone number. So why am I getting text messages from these? Before the Jamaica Data Protection Act, there really wasn't any kind of legislation that prevented companies from buying other people's contact details, your email address, your telephone number, your home address, so that they can market to you. No, under the Jamaica Data Protection Act, that is illegal. You have to give consent, or you have to gain the consent of the data subject in order to do direct marketing. And you also have to provide an opportunity for them to withdraw that consent or to unsubscribe whenever you market to them. Then there is the right to rectifications of inaccuracies. So if a data subject tells you that the information, the personal data that you have on file for them is inaccurate or incorrect, then it is your duty to rectify that. You have to correct the information. Say if you've captured someone's name, the spelling of someone's name incorrectly, and the data subject says to you, my name is incorrect in your system, you have to rectify that. My home address is not correct, my middle name is not correct, my email address is not, whatever it is the duty of the data controller to rectify inaccuracies. Now, if the data subject was the one that provided you with the inaccurate details, then, and there is a cost to rectifying it, then the cost does not necessarily have to be borne by the data controller. That cost can be passed on to the data subject. But if the inaccuracy is as a result of your own fault, then that couldn't be a cost that you pass on to the data subject. And then the final right that we'll talk about is the right to not be subject to decisions that were made only by automated means. And what do we mean by this? Now, we're living in the age of technology. There's all of this machine learning, there is AI, and we're using AI for everything. And more, especially when organizations are processing large volumes of data, organizations will rely on automated technology to help them make certain decisions. So a classic example is creditworthiness. When you apply for a credit card, for example, you fill in a bunch of details on a form. The form goes into an application and they will do some kind of analysis of your financial situation to determine whether or not you are somebody who would qualify for a credit card. They're looking at your age, you're looking at your other debt obligations, they're looking at your annual income or monthly income, other sources of income. They may be looking at whether or not you have any debts outstanding. They're looking at how much you have to pay each month, in expenses and so on. And then the machine spits out a score that says, oh no, Peter Gay does not qualify for a credit card on this. And then you get an automated email that says, unfortunately, we're unable to process, your application further at this point as you do not qualify for a credit card. All of that has been done in an automated way by machines, by artificial intelligence, by computer applications without the single, look of a human being. Under the Jamaica Data Protection Act, you now have the right to say to an organization, I want for there to be some human intervention or want for this decision to be reviewed by a human being because I do not feel as though this was arrived at in a way that was fair to me. Because there may be, some things that the machine doesn't know and didn't ask and doesn't take into consideration. So organizations, you have to tell individuals when you are going to be making decisions using only automated means, and individuals have the right to ask for that decision to be reviewed by a human being. So those are the 6 rights: the right of access, the right to give consent and to withdraw consent, the right to prevent processing, the right to consent to direct marketing, the right to have inaccuracies rectified, and the right not to be subjected to automated decision or decisions that have been arrived at using only automated means. Okay. There are so many questions. I don't even know where to begin. Sansia, do you want to maybe direct some of the questions, any particular questions you want us to field from the chat?
All right, I'm going through. Okay, here's a question. Are companies required to list their data controllers' contact information on their websites and in the forms that they ask clients to complete?
Not the data. So remember, the data controller is the company, is the organization. So presumably, that information is available. What you are required to make available is the contact details of your data protection officer. So organizations must appoint a data protection officer if you're processing large volumes of personal data, or if you're processing sensitive data that to also include criminal records. If that is the case, then you have to appoint a data protection officer, which is either a person or entity that operates in an independent capacity, because remember, this is a statutory function. And I like to say that the role of the data protection officer exists to protect the organization from itself while looking out for the best interest of the data subjects. So imagine an internal audit function, a compliance function, a whistleblowing function, all wrapped up into one. That would be the role of the data protection officer. So in the event that something goes wrong and the data subject, the individual, needs to exercise a right and reach out to the company, generally, they will do that through the office of the data protection officer, your DPO. And in order to do that, they need to know the details. So in your privacy notice, you should generally list who your data protection officer is or the contact details for your data protection officer so that people can get in touch when they want to exercise their rights. When you are registering with the regulator, you are also required to list the details of your DPO as well. So at Securis, we serve as the external DPO for a lot of organizations. So the DPO can either be someone who is internal to your company, or it can be an external individual or entity. If it is someone that is internal to your company, it cannot be anybody who is in a capacity that operates in a capacity that is also responsible for making decisions about how data is processed. Because remember, I said this is also a whistleblowing type of function. No, let's give you a practical example. Let's say, for example, you've appointed your marketing manager as your DPO. Your marketing manager goes out and buys a list of 5,000 individuals from a company off the internet. They just, say, oh, I want 5,000 individuals that are based in Kingston, St. Andrews, St. Catherine, and Portland, and between the ages of 18 and 40, who are male. And they buy this list, and then now they just start sending out a marketing campaign, promoting a new product or service that that's geared towards men within this particular profile. But they did not get the permission, they did not get the consent of these people. Under the Jamaica Data Protection Act, that's a violation, that's a data breach. And this now needs to be reported to the regulator. There are some fines and penalties attached, and we will talk about that in a slide later. Do you think that the marketing manager is going to report themselves to the regulator and face the potential of being fined or going to prison? Chances are no. And that is why the legislation is framed in this way. It says the data protection officer should not and cannot occupy a role within the organization that is responsible for making decisions about how data is processed. It's an independent role reporting to the highest levels within the organization, generally to the CEO. And that is why a lot of organizations will choose to outsource that function to either someone outside of their organization or to a third party. So in the Securus, one of the things that we do is we act as the data protection officer for a number of entities. And that will mean sometimes we will have to field questions and comments and requests that come in from data subjects on behalf of the company. They may say to us, look, I feel as though my data is being mishandled for this reason. Can this be investigated? And that's something that we will have to obviously take up, on behalf of the company and communicate with the data subject. So yes, companies are required to provide the details of the data protection officer, so that individuals can exercise their rights.
All right, one more question. My business sells textbooks and delivers orders to customers seasonally. Many customers are repeat customers. Can I keep their data, such as delivery address, rather than having to collect it each year?
The answer is yes. So if you have repeat customers, and if you're doing business with them every single year, then there is a legitimate, basis for doing so. So the thing is, remember, a lot of it really comes down to noticing and notification. As long as you said to the customer, well, because we deliver to you periodically, we're going to retain your information on file. If you find that you do not do business with this customer in, say, 3 years, for example, then we're going to remove the data. So you have to do some kind of periodic review and clean up of your system. And then you have to decide what that limitation, that retention period is. But yes, in a case like that where you're doing repeat business with a customer, it may not be practical for you to collect it every single time. What you may want to do, though, is periodically ask whether or not the information you have on file is accurate and up to date. Just like when you call a bank, for example, you're in a relationship with a bank in an ongoing basis. And every time you call the bank, even if you call the bank 5 times in one day, they're going to ask you, can you confirm that you still live at number 2 Mount Carmel Close? Can you confirm that your telephone number still ends in 2179? Can you confirm your email address for me, please? Can you also confirm where you are currently working? Because they have a duty to always maintain accurate information about you. So in doing so, you also want to weave into your process a way of verifying that the information that you have retained on file is accurate and up to date. But then you have to also decide what period of inactivity will mean that that person is no longer an active customer. So if it is a case that you've not sold to the person for maybe 3 years, then you can no longer classify that person as an active customer, in which case you probably should not be keeping their details in their address on file in the way that you have. Yeah.
All right, final question. This is a very good one. Please clarify, is it that a small business owner can include personal contacts in their CRM digital marketing activities as long as they provide an opt-out option? Or is it that they cannot do it without prior consent?
So both is required. So in order to market to if you're doing direct marketing, you definitely need a consent. So this is what we have here. So consent is really the basis for which, you know, we start operating. But we always rely on consent as the, so under the legal basis for processing data, consent is one, but we rely on legal basis as the last one, right? There's, you know, there are things like the performance of contract. There's things like legitimate interest. There's things like a legal obligation and so on. So there are some lawful basis under which you can provide, you know, sorry, you can process personal data. The consent piece we say is the weakest and should only be left as a last resort because you consent can be easily given and consent can also be easily taken. And you have to now have a mechanism in place to record the consent, but to also notify you when the consent is withdrawn and then remove the person's details from your CRM system so that you don't send information to the person and so on. So yes, so you have to receive consent, and at every single interaction when you're doing some kind of direct marketing, you have to also give them the option to withdraw that consent, which is the opt-out mechanism. So the consent or withdrawal piece for processing and the consent, you know, definitely required for direct marketing component. So the two of them go hand in hand. Get the consent, but you have to also give them an option to withdraw consent.
Okay. I suspect this is why it's important to have a data protection officer, because this is a lot of stuff to keep up with.
It is. But you know, once you kind of get into the habit of you know, like ingraining, so a lot of it really start with training and sensitization, and we'll get to the road to compliance in a little bit. But once we kind of start getting to the habit of informing everybody within the organization around their responsibilities, then it becomes a little bit easier. So much of this really starts with the training and the sensitization so that people, you know, and that is what the question I responded to first around why some organizations have taken so long to start any activity towards compliance. This is why. I mean, it feels like a lot and it feels onerous, it feels burdensome. But really, when you start to break it down and get into, you know, some of the practical applications, you realize that, oh, it's not so bad. It really just, or we have been doing these things already. We just now need to tighten up on, you know, the way that we've been doing them, or we now need to give it a proper name, whether it is consent or it is legal obligation or it is performance of contract or whatever it is, or the retention period just may need to be tightened up and so on. So it seems daunting, but like I started off by saying we're here to reassure you. It does not have to be that way, and that's obviously also part of why we are here and the role that we've been playing in this space as well. Okay, all right. So sorry.
Can you
Sure.
take a question from Corinne Stewartson? Corinne,
Oh
please make
yes,
it as
Corinne.
possible. We have limited time remaining. Go ahead, Corinne.
Good morning. I have a quick question, and this is something that happens on a daily basis. That's why I thought of asking it. Is it okay for persons to just share your number with whomever? Or should they, because I have received communication from people. I'm like, how did they get my number?
The answer is no, Corinne. They should, you know, and as it's again, while the Data Protection Act really kind of goes to organizations. This, I imagine that this is you're talking about a personal practice where a friend of a friend just gives your number to somebody else and somebody just calls you. But a company should not be sharing your information with a third party without your prior consent or without notifying you in the event that there's a legitimate interest. So you have to either be notified or you have to give consent. But as human beings, it is a good practice. I mean, if someone asks me for someone's number, I always say, let me just quickly confirm with the person that it is okay to provide their number if you don't mind. So allow me some time and I'll come back to you. So definitely it's a personal practice that should be applied. But as far as organizations are concerned, yes, they have to get your consent to share your information in that way, or they have to notify you that they will share your information in the event that they're performing, you know, some kind of if there's a legal basis, a lawful basis for doing so. Yeah. Okay, all right. So let's quickly talk about the processor versus the controller relationship, because this is something, and I defined who a controller is and who a processor is earlier. Remember, I said a controller is any entity that is responsible for deciding how information is personal data that is collected and processed and stored and shared and all of that stuff. I use process there, which is a little bit redundant because all of those are processing activities. And then I talked about the fact that a processor is an entity or person that is contracted by the controller to perform an activity at their direction and can only perform that activity. Now, it is a one-way relationship. It is the controller that gives directions to the processor. The processor cannot give direction to the controller, and the processor should not go outside of the instructions given to it by the controller, because the minute it does that, then it has made itself a controller. But let's talk about an interesting scenario, what we call the accountability conundrum. So in one corner, we have the data controller, the organization that is collecting and storing and analyzing and using personal data. In another corner, we have the processor. This is now a third party that you've contracted to perform a service on your behalf. And at the top here, we have the regulator, right? So the regulator is there to ensure that data controllers are complying with the requirements under the Jamaica Data Protection Act. Now, let's take a practical example. Let's stay with the payroll processing company. Let's say that the controller contracts the processor to carry out payroll functions, but there is a data breach within the payroll company's operations, and they've been hacked. Now, all of a sudden, people's personal data is available online on the dark web and for everybody to see. NIS number, TRN, salary information, people's full name, where they live, all of that stuff is just made available. So that's a breach that has happened because of the negligence of the processor. Who do you think, in this particular scenario, who do you think is going to be held accountable by the regulator? You can unmute your mic and tell me real quickly. Who do you think in this particular case will be held accountable by the regulator? Anybody? Looks like I've lost everybody, man. And if you don't want to open your mic, you can just quickly type in the chat. In this particular scenario that I've just painted, who do you think is going to be held accountable? Okay, Chike says controller. Okay, Tanisha says data controller as well. Anybody says the processor? Remember, it is the processor's negligence that has led to this data breach. Andrew says the processor. Okay, the company. Daniel says the company's the data controller. No, not the data protection officer. I mean the data controller, which is the company. The processor, controller, data controller. All right, so it's a bit of a mixed bag. Latoya says it depends. Martello says data controller. Marlene says the controller. Okay, all right. Now, under the Jamaica Data Protection Act, in this particular scenario, it is the data controller that is going to be held accountable by the regulator, because the regulator or the law assumes that the data controller would have done a couple of things. One, it is assuming that the data controller would have done its due diligence to ensure that the company that you're contracting to perform a service on your behalf is a reputable company with sufficient and robust technical and operational measures in place to keep the data safe in the same way that you are expected to keep the data safe. Two, the law is also assuming that you would have done all your checks and balances to make sure that it's not just what the processor says to you, but also that you have made, you've required, whether it is an audit statement, you may have done some independent verification, you've asked around from other people, and you've done your due diligence in that regard. 3, it is also assuming that you are putting in place contractual clauses within the vendor agreement to notify the processor of its responsibilities as far as keeping personal data safe is concerned. And 4, it is also assuming that you have created data processing agreements, telling a standalone agreement between you, the controller, and the processor, detailing what information should be used and in what way and for what purpose, and and what can happen in the event that the data is not kept safe. Now, if that happens, then it means that as a controller, you can go after the processor in a civil proceeding. So the regulator goes after the controller, and the controller goes after the processor in this particular chain. And I know that in a lot of cases, so some of you maybe processors, you're providing goods and services, or providing services to third party, to other companies. So, in that particular case, you are a processor. Remember, I said that, there was just a data breach and the information became available. Now, if it is a case that the processor was using the information in a way that was not intended or outside of the instructions of the controller, then it has made itself a controller, and in which case it is the processor who now is accountable to the regulator. Because as a controller, you can say to the regulator, well, no, those were never my instructions to the processor. Here it is in writing. We have a vendor agreement, and it says, and we have a data processing agreement. The data processing agreement says that the information should only be used for the purposes of processing payroll. So the fact that the processor is now taking my staff's emails and sending them marketing information, that's nowhere in the vendor contract. That's nowhere in the processing agreement. So the processor has taken it upon himself or itself to make decisions around how the information is being used. And in that particular case, the processor has become a controller. Now, if that can be established, then the regulator goes after the processor, because for all intents and purposes, the processor has made itself a controller. And that is an important point to remember. So again, one of the things that we help our clients with is to look at their vendor landscape. What are your standard contractual clauses that you've included in your vendor agreement? Is there a data processing agreement in place? A data sharing agreement is in place? Have you done the due diligence? So when we look at the vendor due diligence landscape, that's kind of where we often see a lot of gaps and loopholes. And that is likely where a lot of organizations will get caught. So let's quickly then talk just about, where do we begin? So it looks daunting. It looks like there's a lot to do. It sounds like it's really heavy. It sounds like it's clunky. Where do I start? That is generally just the question that is being asked. So we say it's just easy to do some things really quickly, and some of these things you don't necessarily have to even reinvent from scratch. You can find a data privacy policy online that you can customize to your operations. So we say design a privacy policy, because remember that we said the privacy policy is an internal facing document. It is a blueprint or a guideline that exists to guide the organization, everyone within the organization, in terms of how it processes personal data. It's saying that these are the bits, this is our philosophy around personal data. We strive to keep personal data safe, and this is how we're going to do it. And this is how we're going to use personal data. This is how we're going to store it. This is how we're going to share it. This is how we're going to keep it safe. And this is how we're going to delete it, essentially. So that is a really good start, because it brings everybody into a very common operating model as far as personal data processing activities may be concerned. The policy, though, is just a starting point, and that's not enough by itself. So we also recommend that you conduct staff training and sensitization. So you're bringing everybody into this idea that data privacy is everybody's business. Under the law, and I'll talk about penalties in a little bit, there are personal liability components. It's not just the organization that can be fined, but individuals within the organization can also be fined and can also go to jail in the event that it can be established that it is because of their negligence or just willful action, that there is a data breach or leak. So the staff training and sensitization from the security guard who is collecting people's names, license plate number, TRN number, all of that stuff when they come through your premises, all the way up to the senior leadership team who are consuming reports that contain personal data. Everybody across the organization needs to understand what this act also means. Then we say to organization, know your landscape, and that's both the internal and external. What business are you in? So understanding the nature of your business gives you an indication of the kind of data that you need, personal data that you need in order to conduct your business, the legitimate interest. Now, if you are someone that's just selling, beds, for example, just, bed frames and mattresses, why does my mother maiden name, why is that needed? Why is my salary important? Where I work, why does that matter? My email address, is that needed unless you're going to send me? No, if based on the nature of your business and based on your business landscape, you decide that this information is necessary and you can justify that, then that's different. That really only comes from you knowing and understanding your business activities so that you can decide the bits of personal information that will help you to best conduct your business. There is also a requirement for data controllers to register with the Office of the Information Commissioner. Again, this is something that you can do by yourself. You can go onto the OIC's website, onto the Office of the Information Commissioner's website. Organizations will appoint us to do that for them as part of the DPO activities or audit and remediation practice. But this, in truth and in fact, if you have the capacity, this is something that as an organization you can do for yourself. This is important because if you are processing personal data without registering with the Office of the Information Commissioner, you are violating the law. You are in violation of the Jamaica Data Protection Act. In the same way that you are required to register your motor vehicle before you drive on the road, you are also required to register with the Office of the Information Commissioner before you start processing personal data. And the law says that a controller that has not registered with the OIC shall not be allowed to process personal data. And remember what I've said processing is: collecting, storing, sharing, looking at it, analyzing, deleting, any action at all that you perform on personal data. You've processed it. And if you're doing so and you have not yet registered with the Office of the Information Commissioner, you are running dangerously close to problems because you're doing so in a way that contravenes the law. And then you have to comply with the 8 standards. We'll talk about what the 8 standards are. And some of them are actually, not so difficult, but as entities, you have to comply with the 8 standards and also enable data subjects to exercise their rights, because we talk about the 8 standards and the rights of the data subjects together being the nucleus of the Jamaica Data Protection Act. And then finally, we recommend that you appoint a data protection officer that's qualified and independent. What's the cost of non-compliance? Now, the cost of non-compliance, for organizations, it could be up to 4% of annual global turnover. We're not talking about profits. We're talking about turnover, and that's 4%. So for some entities, you may go, that's not a lot of money. But for other entities, when you think about all of their operating companies and all of the jurisdictions that they operate and what 4% looks like, that can actually be significant. But there are also personal fines of between 1 and 5 million Jamaican dollars for individuals who are found to be responsible for instances of non-compliance. And that there's also imprisonment terms of between 2 and 10 years as well. So these are individual personal fines and personal imprisonment terms, for individuals. So it's not just 4% against the organization and it's the organization's problem, but there are individual fines as well, which is why we like to say to organizations that data privacy should not reside with just one person, but it really becomes everybody's business. So what does the road to compliance look like? If I had to simplify it, I'd say we start with executive briefings. So leadership at the top needs to understand the culture that you want to create, the culture of data privacy. Remember, we were saying that we're doing it because it is the right thing to do. So the executive briefings brings the executive leadership team into that conversation. And then there is the training for the general staff trainings and sensitization. Then the second component towards the compliant program is to understand your environment. So it starts with, the a baseline review. What are your current operational practices? How do you compare right now when we look at your practices in comparison to the Jamaica Data Protection Act? And then coming out of that, we can build out a gap assessment or a gap analysis and then develop a road to compliance, which is the remediation roadmap. Once we have a remediation roadmap in place and we know what the gaps are, then we start to build out the implementation. We develop a governance framework. Will you need to appoint a data protection officer? Will you need to appoint a privacy manager? Is that going to be part of internal audit or is it part of compliance? Will it come under legal? Where does IT come into the entire thing? So then the governance program contemplates all of those components. And then we operationalize the program so that we have a framework in place to manage our processing activities on an ongoing basis. And then there is the registration with the regulator. Then we talk about the continuous improvement. So there is regulatory reporting that is required. Organizations are required to submit an annual DPIA, data privacy impact assessment. We're looking more broadly at just data management, so data cleansing and data visualizations that allows us to maximize and monetize data. And then we want to also focus on program optimization, and that's kind of where we start to see the benefits of a compliance program so that it is not just a box ticking exercise, but it is actually returning some value to the organization as part of a much broader data governance program. There are some components, that there are some benefits to the organization. Like I said, it's not just a compliance activity, but the thing that I want to also say is that your customers are paying attention. And a report by McKinsey showed that 87% of customers, they say that they would not do business with a company that they suspected of inadequate security practices, and 71% report that they would stop doing business with an organization that gave away sensitive data. That's significant. So see this as a way of either retaining and expanding your customer pool, or if not taken seriously, you can actually lose customers as a result. So what's our summary and call to action today? 1, data privacy is here to stay. It's not going anywhere. In fact, Jamaica is late to the game. 2, we have to understand what is required of us as organizations under the law. Executive sponsorship at the senior level is crucial because we have to decide on the kind of organization we want to be known for by our customers and our stakeholders. And compliance is really just the first layer in the value stream, but if done right, can really be seen as a business transformation activity that delivers real tangible value to your organization. And the cost of compliance, as you've just seen, is far less than the cost of damage control. And finally, what we say is engage the experts. You can reach us at info@securus.com.jm if there are additional questions, anything that I've said or not said today. Obviously, please feel free to reach out. I know we've been entertaining questions and answers as we've gone along, but we have just a couple of minutes remaining. If there are any other burning questions that haven't been answered, and also please, you can use the email address to reach out if for questions that we probably just did not get a chance to get to in this particular session. Patricia, I see you have a hand up. Lost Patricia.
Look like Patricia disappeared, Andre.
Yeah, that's what I'm seeing. Yeah.
I'm here and I'm thinking to myself, I may have to invite Andre back because I've been trying to download the chat because I want to share it with you, and I hope that's not a breach of the Data Protection Act. But um, I want to share the chat with you because there are so many things in there that could be addressed, but unfortunately, we are so out of time. So I want to just remind you to send me that presentation. I
Yes.
would love to have it so that I can share it with the persons that are in the room this morning. Only the persons in the room this morning, right? Patricia was actually asking you to show her the slide previous to this one. So the penultimate slide, go back to the action slide.
Okay.
Right, that's the one. So persons can please go ahead and take a screenshot of that. Unfortunately, Carlin, I cannot take your question this morning because as I indicated, we're absolutely out of time. I want to thank everybody for joining us this morning. The presentation is going to be shared with you via email, and as indicated, this morning was recorded, and so we will have it on YouTube hopefully by the end of this week. It's been a fantastic morning of information, a lot of information to digest. I hope it was clear. Gregory says it was, so I believe him. Curlin says excellent presentation, and I do endorse that as well, Andre. Very spirited presentation. Unfortunately, Michelle, we won't get a replay, but as I indicated before, please go on youtube.com and look for JBDC Jamaica. Click that subscribe button, and when the program is uploaded, you will be able to access it again in its entirety. Thank you very much, everyone, for joining, and do have a great rest of the day. Thank you again, Andre.
Thank you. You are welcome. Goodbye, everybody.